Good morning, ladies and gentlemen, and welcome to the 16th Willem Vis East International Commercial Arbitration Moot. The case this morning is Farlap Alevamento as claimant versus Black Beauty Equestrian as respondent. And on behalf of claimant, we have the University of Amsterdam, and on behalf of the respondent, we have OP Jindal Global University. And our tribunal this morning is Mr. Ronald Sum, Mr. Fei Ning, and our chair, Mr. Matt Gearing.
Thank you very much for coming to address us at this early hour on a Sunday morning. We appreciate this matter is urgent and we appreciate your attention to these matters. My name is Matthew Gearing. I am the chairman of this tribunal and I'm here, as you know, with my co-arbitrators, Mr. Ronald Sum and Mr. Fei Ning. Now, we are here pursuant to Procedural Order number 1 of the 5th of October 2018. You should be aware that the tribunal has met before these proceedings this morning and has had some discussion of the issues, and therefore we may ask you some questions during the course of your argument. When we ask you some questions, please be assured that we will also extend your time. So we won't penalise you to the extent that we ask you questions that take you out of your flow somewhat. Now, the tribunal is expecting to be addressed on the 3 questions in paragraph 3, subparagraph 1 of Procedural Order number 1. You can let me know in due course if our expectations are correct or not. Can I ask you then, just as we start, whether you have reached agreement on procedure for this hearing?
Yes, we have. Respondent will start on the procedural issues for 14 minutes, followed by claimant for 14 minutes as well. Then respondent will have a rebuttal of 1 minute and claimant a surrebuttal of 1 minute. Subsequently, the merits of the case will be addressed by claimant for 14 minutes, followed by respondent for 14 minutes as well. Claimant will have a rebuttal of 1 minute and respondent a surrebuttal of 1 minute.
Mr. Himatasinga, is that a correct reflection of the agreement you have reached?
Yes, Mr.
Thank you. Thank you. And just so we're clear, when we are talking about the distinction between procedure and substance, by procedure you are encompassing issues 1A and 1B, and substance is issue C. Yes. Very well. Well, that is amenable to the tribunal, and thank you very much for cooperating and reaching agreement on procedure. With that, then, let us hear from claimant on the first part of the argument.
My apologies, Mr. Presiding Arbitrator. A respondent will start on the procedural issues.
May I begin, members of the tribunal?
Please do.
Good morning, Mr. President, members of the tribunal. My name is Karan Himatsingka, and I shall be addressing the procedural issues in this matter. My co-counsel, Mr. Sudarshan Shrikant, shall be addressing the merits of the case. Respondent has 2 submissions in the present dispute. First, that this tribunal does not have the power to adapt the contract, and second, that the partial interim award is inadmissible as evidence. Within my first submission, I shall be extending my arguments in 2 interrelated parts. First, that the law of Danubia governs the arbitration agreement, and second, that under the law of Danubia, this tribunal does not have the power to adapt the contract. Addressing the first part of my first submission, if I may invite the tribunal's attention to page 14 of the record. Page 14 contains the contract entered into between both the parties. Clause 15 on the same page contains the arbitration agreement. The tribunal would notice that the parties have not included an express choice of law provision within the arbitration agreement itself. In international arbitration, 2 presumptions arise out of this. It could either be the law of the seat, which is presumed to apply to the arbitration agreement, which is the law of Danubia, or it could be the law of the underlying contract, which is presumed to apply to the arbitration agreement, which in the present contract is the law of Mediterranean. It is our contention that the law of the seat shall apply to the arbitration agreement, and we base this on the intention of both the parties. if I may read clause 14 with this tribunal. This sales agreement shall be governed by the law of Mediterranean. In contrast, in the same page, the last sentence reads, the parties hereto understand and agree to abide by the terms and conditions as set forth in this agreement. The tribunal would notice that within the same contract, the parties have used two different terminologies. First is sales agreement in clause 14, and second is just agreement in the last sentence. This duality of language can be found across the contract from the very first two words, which can be found on page 13 of the record, which reads, this agreement. Moreover, this agreement can also be found in clauses 2 and clauses 5, whereas sales agreement is just found in clause 14. Therefore, it is our submission that the sales agreement as envisaged in clause 14 by the two parties is restricted to the sales portion of the contract and does not extend to the arbitration agreement. However, as per Article 8 of the CISG, to better understand the intention of the parties while drafting this contract, I shall proceed to show this tribunal the negotiations which ensued on this point. In this regard, if I may invite the tribunal's attention to page 33 of the record.
Just before you go there, you are pressing upon us, as I understand it, a position whereby you say Danubia law governs the agreement to arbitrate as opposed to the law of Mediterranean, which governs the agreement, or as you say, the sales agreement. And we note your points on the distinction between agreement and sales agreement. That is because, as I understand it, you say Danubia law imports or imposes a four corners approach to the tribunal's jurisdiction.
Yes, Mr. President.
But is this then, and this is a question the tribunal have and will have for both of you, is this a point, is our ability to interpret the contract, to adapt or interpret, but certainly to adapt the contract, is it a point which is governed by the law of the agreement to arbitrate, or is it a point of substantive law arising under the general body of the law of contract? That's a question the tribunal had.
Members of the tribunal, it is our submission that the powers to adapt the contract can be derived by this tribunal from the arbitration agreement itself. And therefore, the arbitration agreement, which is in clause 15, needs to be looked at by this tribunal to consider whether the powers of adaptation have been conferred on this tribunal.
Thank you.
In this regard, in page 33, which contains an email from respondent to claimant, if the tribunal is with me,
Yes.
if I may read the first para, the third line, that the sales agreement shall be governed by the law of Mediterranean.
Yes.
In the very same email, a draft arbitration clause was proposed by my client, which in the third last line had a choice of law in favor of the law of Equatoriana. Therefore, if sales agreement in the present email was to include the arbitration agreement, then we would have two different laws apply to the arbitration agreement, which would not have been the intention of my client.
Yes.
Therefore, it is our submission that even as per the intention of the parties, as shown in the negotiations, the sales agreement is restricted to the first 14 clauses, and therefore the law of Mediterranean 2 only applies to the substantive portion of the contract and not to the arbitration agreement.
And very shortly, why do you say that we can look at the negotiation material at all?
Mr. President, as per Article 8, Clause 3 of the CISG, the tribunal can look at pre-contractual and post-contractual negotiations to determine the true intention of the parties.
Thank you.
And therefore, it is our submission that these negotiations can be looked at.
Thank you.
Moving to the second part of my first submission, which is that under the law of Danubia, this tribunal does not have the power to adapt the contract.
Last question. I direct you to page 11 of the documents. See, in your email, the last paragraph, you said that we could accept the principle of the law of Mediterranean if the courts of Equatoriana have jurisdictions. And then claimant's reply on page 12 was that it is, however, not acceptable that we submit to the jurisdiction of the courts of Equatorial. A possible solution, if you cannot agree on the jurisdiction of the courts, would be to opt for arbitration in Mediterranean. And then your reply was, the seat of the arbitration shall be Equatoriana, and then the law of this arbitration shall be the law of Equatoriana. Now, so is it possible that you can, given the similarity between Mediterranean and Equatoriana, that you have no objection in the use of the Mediterranean law, because given the similarities of the two systems?
Mr. Arbitrator, the reason why we proposed the law of Equatoriana was not due to the similarities between the law of Equatoriana and the law of Mediterranean, but rather because we did not want the dispute resolution process or the entire contract to be skewed in favor of either parties. In the interest of neutrality, we had proposed that the underlying contract could be governed by the law of Mediterranean if the entire dispute resolution process, including the seat and the law, were in Equatoriana. Therefore, in that interest, we had proposed the law of Equatoriana and not due to the similarities between the two laws. Proceeding with the second part of my first submission, which is that under the law of Danubia, this tribunal does not have the power to adapt the contract. Danubian contract law is a verbatim adoption of the UNITRA principles of international contracts. However, Article 6.2.3, Part 4b of Danubian contract law is worded differently and grants the powers to courts and arbitral tribunals to adapt the contract in cases of hardship only if authorized. This authorization must come from within the four corners of the contract itself, as Article 4.3 of Danubian contract law replaces the rules of interpretation with the parole evidence rule. As within the four corners of the contract itself, the parties have not authorized this arbitral tribunal to adapt the contract, it is our contention that under the law of Danubia, this tribunal does not have the power to adapt the contract. Moving to my second submission, which is that the partial interim award is inadmissible as evidence.
Yes.
I shall be extending this argument in two parts. First, that the confidential nature of the partial interim award and the improper procurement of the same precludes this tribunal from admitting the partial interim award. And second, that it does not meet the test of relevancy and materiality as laid down in Article 22 of the HKIAC rules, which is the rules governing this arbitration proceeding. Proceeding with the first part of my first submission. The previous partial interim award rendered by another arbitral tribunal within the HKIAC was governed by a duty of confidentiality as espoused in Article 42 of the HKIAC rules of 2013. Therefore, considering the confidential nature of the partial interim award and the principle of confidentiality, which is generally respected in international arbitration, it is our submission that this tribunal should not admit the partial interim award.
Can I just ask you, I think maybe two questions there. First of all, and this may more be a question for claimant, so we'll come to this in due course. What is your current understanding as to the status of the second, the award, the disputed award, if you like? And in particular, is it in the public domain or not?
Members of the tribunal, it is our contention that the partial interim award is not in the public domain, as only an intelligence company has procured it, and claimant itself has still not procured it from the intelligence company, even after paying a consideration of $1,000.
Yes.
In that case, it is not readily available in the public domain itself, and it is our contention that the partial interim award should not be admitted for those reasons.
So if you are right, and we will hear from the claimant in a moment on that, and the claimant itself does not yet have the award in its hands, and indeed the claimant hasn't yet provided the tribunal or offered to provide the tribunal with a copy of the award, do you say the application is premature?
Mr. President, it could be said that claimant's application is premature
Yes.
and that they cannot attest to the relevancy and materiality of the partial interim award without ever reading it or procuring it. Which brings me to my second submission, that is, the test under Article 22 of the HKIAC rules has not been met. We do understand that this tribunal has broad discretion under Article 22 of the HKIAC rules to admit any evidence it considers relevant and material to the present dispute. The test of relevancy and materiality is whether a party is trying to prove a fact upon which its legal arguments rest. In the present dispute, claimant does not wish to bring the partial interim award to prove a fact, but rather to show that respondent has adopted two different legal positions in two different legal proceedings, which is within the right of respondent, especially considering the different factual circumstances of both the previous proceeding and the current proceedings. We identify mainly two differences in the previous contract and in the current contract, which are material for this tribunal to consider while determining whether the partial interim award is relevant and material. First, Mr. Arbitrator, I sense a concern.
Yeah. I'd like to hear from you regarding the HKIAC rules 22nd.2. Basically, based on that rules, tribunal has the discretion power to decide whether accept the evidence or reject evidence. So based on that article, what do you think about tribunal should thinking about any other circumstance or any other reason or elements except that rules?
Mr. Arbitrator, even though 22.2 does give this tribunal a broad discretion to admit any evidence, previous tribunals have considered other circumstances like the confidential nature of information or the improper procurement of the same. Even though this tribunal is not bound to consider those circumstances, it is a submission that they should give consideration to these. Members of the tribunal, I also sense that I've exhausted my time. If I may seek an extension of 30 seconds to complete my submissions.
Yes, please do, and don't fear, you can go a little bit beyond 30 seconds because we have asked you a number of questions and we won't hold you to strict time.
Thank you, Mr. President. Coming to the two differences between the previous contract and the current contract. The previous contract had a model HKIAC clause, whereas in the current contract, the parties have explicitly narrowed down the HKIAC model clause and removed words like relating to the contract. This shows that the parties have narrowed down the powers of this arbitral tribunal, and therefore this material differences does come into account while deciding the similarity between the two contracts. Moreover, in the previous contract, the parties had adopted the ICC hardship clause of 2003 in its verbatim form. However, in the present proceedings, the parties have explicitly rejected the ICC hardship clause. Considering these dissimilarities, it is our position that the partial interim award is neither relevant nor material to the present dispute. To conclude and to summarize, we submit that this tribunal does not have the power to adapt the contract under the law of Danubia, and that the partial interim award should not be admitted by this tribunal. Thank you, Mr. President. Thank you, members of the tribunal.
So just before, thank you very much, that was extremely helpful. Just before you go, I understand the gist of your answer, but please clarify to Mr. Feining's question, is that you accept that Article 22.2 gives the tribunal a broad discretion to admit or exclude evidence, but you say that it should be exercised in the light of certain other factors. And are you saying, in a sense, that public policy is one of those factors, and public policy includes documents, includes points around documents which have been improperly procured?
Mr. President, it is our submission that these factors do come into light when the enforcement of the award would come in before the courts of either countries. And therefore, in light of this tribunal should consider these factors, because it would not be the intention of the tribunal or either of the parties to have an award which is unenforceable. If that answers your question, Mr. President.
Thank you very much. Thank you very much, respondent. Now we turn to claimant. You may wish to have regard to some of the questions, but we may put those questions or different questions to you, and you will also have some latitude on timing.
Thank you. Mr. Presiding Arbitrator, members of the Tribunal, on behalf of Claimant Farlap Alavamento, my co-counsel Stijn Wilbers will address the merits of the case. My name is Caroline Groepsema, and I will address the procedural issues. Claimant requests the Tribunal to find that it can adapt the contract and that the evidence is admissible. Claimant and Respondent were to mutually benefit from their contract. However, the recently imposed tariff destroyed the commercial basis of the deal for Claimant. After this tariff was imposed, the parties started renegotiating on contract adaptation. These negotiations were broken off by Respondent. Claimant was therefore forced to start these arbitral proceedings pursuant to Article 4 of the Hong Kong Rules and ask the Tribunal to adapt the contract. On behalf of Claimant, I will make two submissions. First, that the Tribunal has the power to adapt the contract. And second, that the evidence is admissible in the current proceedings. Both these arguments are contrary to opposing counsel's statements. Proceeding to the first submission, that the Tribunal has the power to adapt the contract. Opposing counsel stated that the Nubian law applies to the arbitration clause, and that secondly, the Tribunal has the power to adapt the contract, does not have the power to adapt the contract. However, this is incorrect, based on the following two arguments. First, Mediterranean law applies to the arbitration clause, because parties impliedly chose Mediterranean law. And secondly, the Tribunal has the power to adapt the contract, because the parties have expressly authorized the Tribunal to do so. As to the first argument, that Mediterranean law applies because parties impliedly chose this law. Opposing counsel state that there were two different factors to be taken into account, either the law of the main contract or the law of the seat. I would like to refer to an approach to find the applicable law to the arbitration clause in case there is no express choice of law in the arbitration clause itself. And we follow the approach contained within the BCY versus BCZ case rendered by the Singapore High Court, a model law jurisdiction. And this approach is the following. First, it must be assessed whether parties made an express choice of law in the arbitration clause itself, which they did not in this case. And secondly, it must be assessed whether parties made an implied choice of law. And in the present case, parties made an implied choice of law for Mediterranean law. If I may take the Tribunal to the contract again on page 14 of the case file. Clause 15 does not contain an express choice of law, but Clause 14 reads that this sales agreement shall be governed by the law of Mediterranean. This express choice of law for the main contract is an implied choice of the parties for the arbitration clause itself. It was stated by Professor Julian Liu that the law of the main contract is a strong indicator towards the parties' implied choice for the arbitration clause. And furthermore, in the aforementioned BCY versus BCZ case, it was stated by Judge Chong in paragraph 74 that the starting point that the law of the main contract applies to the arbitration clause can only be deviated from if the law of the main contract would negate the arbitration clause. In the current proceedings, the law of Mediterranean, the law of the main contract, does not negate the arbitration clause, and therefore the parties did not deviate from this starting point.
But neither, if I can make a comment and a question there, my understanding of that principle is that if there is a choice between choosing the law of the agreement to arbitrate or the law of the seat or the law of the substantive contract for the law to govern the agreement to arbitrate, if choosing one rather than the other would invalidate the agreement to arbitrate, then that would obviously point one in the other direction. But in neither case here, whether one is choosing Danubian law or Mediterranean law, will the agreement to arbitrate be invalid, will it?
Correct. Neither of the laws would render the award invalid.
Yeah.
However, as was stated, for example, also in the Sul-America case, which has the same approach as the BCY case, that if the law of the main contract invalidates the arbitration clause, this is a deviation from the starting point. But the starting point always states that the main contract should first be looked at, as parties expressly chose this law to be governed by the contract, and this encompasses, in that sense, the whole contract. And opposing counsel referred to the terminology of sales agreement. However, the definition of the whole contract is also called the frozen semen sales agreement, so this should not make any difference in this instance. And opposing counsel also referred to page 33 of the case file.
Just before we
Yes.
leave the contract, what do you say about the point concerning the place or the numbering of the clauses, in that clause 14 refers to the sales agreement Mediterranean law, and then only after that does one then get into the agreement to arbitrate at clause 15? Is that a relevant point?
I would say that that is not per se a relevant point, because still the arbitration clause is included in the contract itself, and whether it comes after or for the main contract express choice of law provision does not matter, because the arbitration clause still does not include any express choice of law. So this is the strong indicator towards the party's implied choice still.
Thank you.
And turning to page 33 of the case file, if I may take the tribunal there, where the opposing counsel referred to also. And opposing counsel stated that it was my client's intent, or his client's intent, that the law of Equatoriana would govern the arbitration clause, and the seat would be similar. However, this is only a proposition of respondent. This is not any intent of the parties both. Furthermore, the law applicable to the arbitration clause governs the interpretation and validity of the arbitration clause. And is there a question?
No, please.
Okay. And the interpretation standard, according to Equatoriana and Mediterranean, is the same sort of broad interpretation standard, contrary to the law of Danubia, which has the four corners rule. And therefore, this intent of respondent merely shows that it would rather have Mediterranean law applied to the arbitration clause than the law of Danubia. In the final arbitration clause, no express choice was included, and therefore we turn to the starting point that the law of Mediterranean also governs this arbitration clause. Because Mediterranean law applies to the arbitration clause, we can interpret clause 15 in a broad way. If I might take the tribunal again to clause 15 on page 14 of the case file. Clause 15 reads, any dispute arising out of, including the interpretation and performance thereof. In the merits, it is about an interpretation of clause 12, which is thus a dispute arising out of the contract, an interpretation thereof. And furthermore, to assess what parties intended with the word performance, we can look at the intent of both parties. This is because if Mediterranean law applies to the arbitration clause, we can use the CISG for the legal standard of the interpretation. And according to Article 8, Paragraph 3, all circumstances can be taken into account for this intent. And one of the circumstances could be the domestic law of both parties. Both parties, Equatoriana and Mediterranean, have a contract law which has an article on adaptation. This article is Article 6.2.3, and this is included in the performance section. Thus, it is intended by both parties that adaptation is included in this arbitration clause.
But that's a point of substantive law, isn't it? As you may recall, my question to respondent is a question the tribunal had about whether the power of adaptation is a power, whether it has anything to do, in fact, with the question of the governing law of the agreement to arbitrate, or whether it's a point of substantive law, so whether all along one should be looking at Mediterranean law.
Yes. Well, it brings me to my second argument, that the tribunal is expressly empowered to adapt the contract, because opposing counsel referred to Danubian contract law for the powers of the arbitrators. However, if Danubian contract law would apply to the arbitration clause, this only has an effect on the interpretation of the arbitration clause. The powers of the arbitrators are derived from the lex arbitri, Danubian arbitration law. And Danubian arbitration law contains Article 28, Paragraph 3. This article stipulates that for the tribunal to adapt the contract, there must be an express authorization by the parties. But what does express mean? Express does not mean in express wording, but it was stated in the working documents of the untruthful model law that express can also be derived from the significance and purpose of the agreement. And coming to the substantive law point, it was stated by Professor Christoph Brunner and Professor Klaus-Peter Berger that the powers of the arbitrators can also be derived from the substantive law. If parties specifically choose a substantive law which allows for contract adaptation, then this can be seen as an authorization of the tribunal to adapt the contract. Otherwise, the substantive law would become moot. In our case, the substantive law is law of Mediterranean, which contains Article 6.2.3, paragraph 4b specifically. And this article requires the tribunal to adapt the contract without any restrictions. Thus, the legal standard of the Danubian arbitration law is met, and the assertions of opposing counsel that there is no power because our adaptation would not be encompassed in the arbitration clause is thus incorrect.
Actually, I want to bring you back to a point. Okay, please clarify a point that I have on the conflict of law issues. I mean, the Danubia court is the supervisory court. Now, if one of the parties appeal against the tribunal's decision, say whatever decision it is, so under the Danubia Arbitration Act, then, and if the agreement, the arbitration agreement is governed by Mediterranean law, what will happen to this instance of conflicts of laws arising?
There would be, in that instance, no problem, because if we would go to Danubian courts, for example, for a setting aside or enforcement proceedings, then the court would see that the arbitration adaptation is included in the arbitration clause, thus the tribunal would not exceed its scope, and the legal standard of the lex arbitri, Danubian arbitration law, is met because parties expressly authorized the tribunal to adapt the contract. Thus there will be no conflict of rules problems, because it can be that a different law applies to the interpretation of the arbitration clause than the seat itself.
Thank you.
Thank you. If there are no further questions on the first issue, I will turn to the second submission, that the evidence is admissible. Opposing, oh, sorry.
Just as you get into that, because I think these are points that affect the whole issue, and you will have heard me and my fellow arbitrators ask respondents about these points. First of all, do you have in your hands a copy of the relevant award?
We do not have a copy of the award in our hands, but we can acquire it through a company.
And how can you acquire it?
We will pay $1,000 to that company to acquire the award, which, and the award was, we heard about the award at the annual breeder conference of Mr. Velasquez, who was already talking about the partial interim award. And later, it turned out that the company is in the hands of this award. We can acquire it through this company.
So how do you know that the award is something that you wish to rely on and you wish to adduce before us if you haven't seen a copy of it?
Well, what we know is reflected in Procedural Order number 2 on page 60 of the case file, paragraph 39. And I will summarize why we are using this award. It is for a matter of fact, which is also important for the relevance and materiality encompasses in Article 22.3 of the Hong Kong rules. It is relevant because we are showing a matter of fact. Parties concluded their contract on the 6th of May 2017. And after this contract was concluded, the government of Mediterranean imposed a tariff. The partial interim award presumably shows that respondent did not expect this tariff to be imposed.
But isn't that, you said presumably shows, isn't that the problem? And does that not take one to the second question that I think I asked respondents on this point? Is your application not premature because you've candidly accepted, and we appreciate your candor, and we welcome that you don't have a copy of the award in your hands. You're presuming that it's something you wish to rely on. You're also presuming that you will be able to get hold of a copy, but you don't yet have a copy. So is your application not premature?
My apologies. I would like to restate my words because as reflected in Procedural Order number 2, in the other proceedings, respondents stated that addressed the ICC hardship clause, which has a standard of foreseeability. Thus, it shows that respondent did not expect this tariff to be imposed. And this is important for our interpretation of Clause 12, which will be addressed in the merits of the case. The partial interim award is the only document which shows that respondent did not expect this first tariff to be imposed. And therefore, it is important for claimant to introduce this award to be able to fully present its case. And may I ask the tribunal for an additional minute?
Please do, and you can go a little bit beyond that because, again, we accept that we've disrupted your flow.
Thank you very much. Opposing counsel relied on the relevance and materiality and stated there were two factual differences. However, the fact that we are trying to, that we want to wish to use the partial interim award for is not displaced because of these two facts. And secondly, opposing counsel stated that because the award is confidential, it should not be included in these proceedings. However, the confidentiality of the award, claimant is not bound by any confidentiality of that award. It does not stretch to claimant as a third party. And furthermore, respondent knows what is in the partial interim award. Claimant will soon know what is in the award as well. Only the tribunal does not know what is in the award, and these proceedings are confidential, also pursuant to Article 22.7 of the Hong Kong Rules 2018. This is thus not of any concern. And this concludes also claimant's procedural submissions.
Can I ask you one further question? If the award was in the second award, the disputed award that we're talking about was in the public domain, for example, if it appears on one of the websites where one sometimes sees awards, would that change the position as regards your application? Would you then be able to rely on it as a document in the public domain?
We could then rely on it as a document in the public domain. Then it is not, the award is not confidential, but it doesn't matter in our case, as the confidentiality is also not an issue in this instance, as claimant is not bound by this confidentiality. And the tribunal is neither, because it's not the same tribunal as in the other proceedings.
Thank you.
Let's assume that the tribunal is not prepared to admit the evidence. Just let's assume that. We have not decided yet. Can you tell us what conditions you may direct the tribunal to put on the order so that the tribunal can direct the admissibility of the evidence? In other words, if the tribunal is not prepared to do it, what would you say to us? Is there any conditions that the respondent shall put on the admissibility of evidence so that it is admissible?
Well, we could ask for a document production that respondent has to, that respondent should include this evidence as a document production. We did not choose this way because it would stall these proceedings, which are already costly for my client. Therefore, we first tried through this way.
Thank you. Well, that's extremely helpful, both of you. Thank you very much. I think that then, so you had the opportunity to reply, please.
Members of the tribunal, I have one point in rebuttal. Counsel for claimant says that they wish to prove that the tariffs were unforeseen using the partial interim award. I have 3 points on that question. First, as pointed out by the members of the tribunal, the partial interim award has not been procured by claimant, and hence it's not sure whether the partial interim award shall show that the tariffs were in fact unforeseen. Second, that the partial interim award, even if it shows that the tariffs of Mediterranean were unforeseen, it does not show that the tariffs imposed by Equatoriana were also in fact unforeseen. The third point is that unforeseen is judged at different points of time, that is, at the time of conclusion of the contract. Therefore, even if at the time of conclusion of the previous contract the tariffs might have been unforeseen, it is to be seen by this tribunal whether on 6th May, which is the date when this contract was concluded, whether the tariffs were unforeseen or not. Thank you.
Thank you very much.
Opposing counsel referred to the difference in time and that is important to look at the conclusion of the contract. Well, this is exactly important why we want to use this fact. The contract was concluded on the 6th of May 2017. The first tariff was imposed in November 2017. Respondent did not expect this first tariff. The second tariff that my client is facing is a retaliatory tariff, a reaction to the first tariff. As respondent did not expect this first tariff to be imposed after the conclusion of the contract, it could certainly not have expected the second tariff to be imposed. Therefore, the award is inadmissible as it is relevant to our case. Thank you.
Can I ask you both one further question about this before we move on to the second stage? If we did admit this award, and it might be said to be difficult because you don't have sight of it and we don't have sight of it, but imagine, go forward, that we did admit it. Would it bind us in any sense, and in particular, would it create any res judicata or issue estoppel?
Well, first of all, the tribunal is not bound by any other awards. And secondly, estoppel is not a problem. We are not saying that respondent cannot take conflicting positions. We are just showing a matter of fact that the first tariff and thus the second tariff is unforeseen for a respondent.
Respondent, would you like to deal with that question briefly?
Members of the tribunal, as already clarified by the counsel for claimant, the partial interim award is not going to be binding on this tribunal.
Yes.
And therefore, it also lowers down the relevancy and materiality of the partial interim award before this tribunal.
Thank you.
We also concur with claimant on the second point that estoppel is in no way binding on us and that we can take up two different legal positions in two different legal proceedings.
Thank you. It's certainly helpful when we arrive at a situation when counsel are able to agree on some matters. So the tribunal appreciates that. Now, I think that concludes the argument on issues 1A and 1B. We will now then turn to deal with issue 1C, and at least as framed in procedural order number 1, there are two subparts of that issue, so we look forward to hearing from you both on that.
Mr. Presiding Arbitrator,
Yes.
members of the tribunal, my name is Stijn Wilbers and I will represent claimant on the merits. Claimant requests your tribunal to order respondent to pay $1.25 million. When parties concluded their agreement on the sale of frozen horse semen, they envisioned a long-term relationship. However, once claimant paid for the tariff, respondent hung claimant out to dry. The mutually beneficial cooperation thus turned into a financial nightmare for our client, who might now be forced to sell part of its business. These changed circumstances justify an adaptation of the contract, and respondent should be ordered to pay $1.25 million. This is based on the following two submissions. First, that respondent should be ordered to pay the claim on the basis of the contract. And second, that in the alternative, respondent should be ordered to pay the claim on the basis of the CISG. I will now proceed to the first submission, that respondent should be ordered to pay the claim on the basis of the contract, specifically on the basis of Clause 12. I will first address why the tariff meets the requirements of Clause 12, and then I will address the remedy that is to be provided, which is a remedy of adaptation. If I can invite your tribunal to turn with me to page 14 of the case file, where you will find the contract, and specifically Clause 12 contained therein. Clause 12 reads, "Seller shall not be responsible for hardship caused by additional health and safety requirements or comparable unforeseen events making the contract more onerous." To determine the effect of this clause, it should be interpreted in accordance with the intent of parties, pursuant to Article 8.1 of the CISG. Article 8.3 states that for this interpretation, all relevant circumstances, including the negotiations of parties, should be taken into account. Before discussing the individual requirements, I would like to take your tribunal to the very reason why Clause 12 is here, the most crucial part of the negotiations.
So just whilst we're looking at that clause, and it's very helpful for you to have placed it in front of us, which words do you place particular emphasis on in Clause 12?
The three key words are comparable, unforeseen, and onerous. These are the requirements that need to be met for the tariff to fall within the scope of the clause.
And how do those three words relate to the reference to hardship, which appears in the previous line?
These three words refer to the qualification of the event that needs to have caused the hardship that our client wishes to receive an adaptation for. To understand, if that addresses it, yes.
Thank you.
To understand the requirements and the purpose of this clause, it is useful to look at the origin of this clause, which can be found on page 12 of the case file. Here you will find an email by client's representative, Ms. Napravnik. She states that while accepting DDP, she wishes to deviate as claimant did not want to take over any further risks associated with the change in delivery terms, the change from EXW, under which our client would bear no risks, to DDP, under which it would usually bear a full amount of risks. She specified that our client in particular did not want to take over those risks associated with changes in customs regulations or import restrictions, such as the tariff. Accordingly, she states at the bottom of the very same paragraph, that for that reason a hardship clause should be included. This hardship clause is clause 12, and respondent understood that these were the risks that our client was to be exempted from, as it pointed to these risks when it suggested the wording. Perhaps it is useful to look at the commercial logic behind this clause. The clause is there because our client in the past experienced sudden government measures that led to hardship. These government measures were then additional health and safety requirements. That was the example it referred to, and the purpose of this very clause is that it exempts our client from the responsibility for sudden government measures that increase the cost. With this in mind, I will now turn to the individual requirements. The first requirement is the comparability. The tariff is comparable to health and safety requirements because both health and safety requirements and customs tariffs fall within the broader category of customs regulations and import restrictions that was the purpose of this clause to exempt our client from. Second, both health and safety requirements and tariffs are comparable in their nature. They are government-imposed measures that restrict the import. And finally, a crucial aspect is that their effect. This effect is that both the example of the health and safety requirements and the present tariff destroy the commercial basis of the deal. While we admit that there are some technical differences between these health and safety requirements and the tariffs, I appeal to your tribunal to look at this in accordance with the understanding that a commercial party would have. And a commercial party would understand that the purpose would look at the purpose and the effect. The purpose is that this clause exempts our client from responsibility for sudden government measures that increase the cost. That is what tariffs do, that is what health and safety requirements do, and it is therefore comparable. Turning to the second requirement of the onerousness. While opposing counsel might refer...
Sir, can I just stop you there? You refer to page 12, your letter to the respondent. Now, it's quoted in that letter in the fourth paragraph on the second line, in particular, not those associated with changes in customs regulations or import restrictions. Now, but when you're looking at the comparable issues, okay, dealing with health and safety, then wouldn't it be correct to say that if claimants are so concerned about this issue, why don't you put it there in the contract itself, rather than leave it in a broader sense, as you put it, the health and safety requirements?
I understand your confusion here, and it is our argument that the intent here was crystal clear, namely that it would exempt our client from customs regulations and import restrictions. If this intent is, however, not clear enough, then the understanding of a reasonable third person should be used. In that case, it would be relevant that the contra pro forentum rule applies. It was respondent who drafted the wording for this clause, and respondent who then referred to these risks, which made our client feel assured that they were covered. If that... Sorry.
Yeah. My question is regarding Article 12. That article actually give you a rise if hardship situation happened. Then you may discharge from the contractual obligation. However, my question is whether, based on that article also provides your rights to raise your claims for such situation.
Do I understand your, Mr. Arbitrator, correctly that you are referring to the remedy that is to be provided?
Yes.
I'll now turn to the remedy before returning to these requirements.
Okay.
The remedy that is to be provided in accordance with the intent is the remedy of adaptation. Certainly, in the wording of the clause, we can read a force majeure remedy. However, it was parties' intent that adaptation would be possible. If I can take your tribunal to page 17 of the case file. Here you see a statement by Mr. Pravnik, who in the middle of the page, in the second paragraph, stated that our client wished for adaptation to be possible, and that respondent's representative, Mr. Andley, and I quote, in the third line of the second paragraph, replied that in his view it should probably be the task of the arbitrators to adapt the contract. There was thus a common intent for adaptation to be possible, and this adaptation should be granted as the requirements of the clause are met. Turning to the second requirement of the honor.
Do we have any evidence from Mr. Antley?
The evidence for Mr. Antley is not there, but what is in any case stated furthermore in this witness statement is that Ms. Napravnik suggested an express reference into the hardship clause, and Mr. Antley actually promised a proposal. If your tribunal, however, finds that this is not sufficient for a common intent, then the reasonable understanding of a third party would have to be used, pursuant to Article 8.2. For this, it would be relevant to look at the domestic law of both countries, both of which provide 3 remedies in the context of hardship: renegotiation, adaptation, and termination. Parties have rejected 2 of these remedies through the rejection of the ICC hardship clause, leaving 1 remedy for hardship as a remainder. This remedy should be granted as the honors requirement is also met. Opposing counsel might refer to high thresholds that apply, but parties have actually intended for a low threshold to apply, as they rejected the ICC hardship clause containing excessively onerous in favor of the standard of plain honorousness. Converting a $250,000 profit into a $1.25 million loss certainly meets this requirement. The final requirement is that it must have been unforeseen. And again, it is relevant here to note that it is unforeseen that is the standard, a subjective standard.
This is a test. The unforeseen standard is a test which one has to apply as at the date of the contract. Is that right?
Certainly.
Yes.
And it is not unforeseeable, actually, that is the test. And this might be something that opposing counsel refers to. Unforeseeable would mean whether parties could have foreseen. The test here is plain and simple, whether parties factually foresaw the tariff. And they did not. At the time of the contract, the tariff had not been imposed. When it finally had, after 9 months, even informed circles were surprised, and certainly our client was. And also referring to the partial interim award, opposing counsel on the procedural matters stated that there is no relevance in the award. What it actually does show is that respondent apparently was able to invoke the ICC hardship clause, which contains the standard of unforeseeable. It thus argued that, or it apparently found that the Mediterranean tariff that was the origin for this retaliatory tariff was unforeseeable. If respondent found that unforeseeable, certainly this was unforeseen.
So you draw a distinction between unforeseen, which you appear to be saying is a subjective test, and unforeseeable, which is an objective test. Is that right?
Certainly.
Yes.
Concluding the submission on the contract, the requirements of the clause have been met, and therefore adaptation should be granted, thus awarding the claim. I'll now turn to the second submission, that in the alternative, the claim should be awarded on the basis of the CISG.
I do have one question. Dealing with the words onerous. Now, once again, you refer to page 12 of your letter. And it says, increase, on the 5th line, it says, increase the cost by up to 40% and thereby destroy the commercial basis of the deal. Now, obviously, I understand where the claimant is coming from when you're talking about turning a $250,000 profit to a $1.25 million loss. But when you look at it on a percentage basis, this is only a 30% increase in the cost. And in the letter, you said 40% increase in the cost was destroy the commercial basis. But here, only 30% increase in the tariff by percentage-wise. Does it make it onerous?
I understand your concern in this regard. However, it is crucial to read that it says up to 40%, thus also encompassing the current 30%. And moreover, the determining part here is the destruction of the commercial base of the deal, which has taken place. On the CISG, I will make 2 arguments. First, that Article 79 governs hardship, and second, that the requirements of Article 79 have been met. While it was unclear for some time whether the article governs hardship, it is now generally held that it does. Professor Schrenzer, Professor Kroll, Professor Atamer, amongst others, state this, and it was furthermore confirmed in the CISG Advisory Opinion number 7. Article 79 thus governs hardship, but there is a problem, because it only provides a force majeure remedy of an exemption from liability for a failure to perform.
If we decide, the tribunal wondered about the application of Article 79 in the light of Article 6, of the convention, which says the parties may exclude the application of this convention or, subject to Article 12, derogate from or vary the effect of any of its provisions. Now, if Clause 12, Article 12, deals with hardship in some sense, whether broad or narrow, but assume at the moment it's narrow, then would that be sufficient to invoke Article 6 to exclude Article 79, so sort of cut it off before one gets there?
Before answering your question, might I ask for an additional 2 minutes to conclude the CISG submission?
Please do, and a little longer if you wish, because we accept we have asked you a number of questions.
Thank you very much. I understand your concern regards the derogation article. And for the derogation, it is held that a cognizable intent is required. Such a cognizable intent is not there, and actually the function of Clause 12 is to clarify rather than derogate from Article 79. Article 79 governs hardship, and the problem I analyzed was that there is only a force majeure remedy. If Article 79 governs hardship, hardship must be allowed to properly function in the CISG. To leave it only with a force majeure remedy would be to create a bird without wings. It is in accordance with the CISG advisory opinion that in hardship, further relief can be granted in accordance with the principles underlying the CISG. On the basis of Article 7.2 of the CISG, one of these principles is the principle of good faith. And in the present specific circumstances, it would be in accordance with the principle of good faith to provide the remedy of adaptation. This is because our client performed and would thus be left without a remedy because of respondent's actions. Respondent's representative, Mr. Shoemaker, knew our client would not deliver if he would have rejected its request outright. He thus concocted a strategy together with his wife, who's a lawyer, and to induce our client into delivering with the promise of negotiations. To be fair, negotiations did take place, but they were for show, as after being confronted with our discovery of the illegal resale, respondent's CEO angrily ended the meeting and refused to address any of our client's concerns. These present specific circumstances therefore justify adaptation on the basis of good faith. This adaptation should in the present case be granted as the requirements are met. Claimant could not reasonably have foreseen, taking the tariff into account, as previously addressed, even informed circles were surprised, and therefore this requirement would be met. With regard to the threshold, opposing counsel might refer to high standards that apply, but in the present case there are circumstances for a relatively low threshold. These circumstances are the illegal resale of doses of the semen by respondent. Not only is our client subjected to hardship, but also are its assets endangered, the semen of Nijinsky 3, by this illegal resale. This would therefore justify a relatively low threshold, and this threshold is met as the $250,000 profit undergoes a negative five-fold conversion to a $1.25 million loss. Finally, claimant could neither have overcome nor have avoided these tariffs, and therefore the remedy of adaptation should be granted. Concluding the two submissions, both on the basis of the contract and in the alternative on the basis of the CISG, should the claim be awarded. Thank you.
Thank you very much. Just before we turn over to respondent on this, going back to the first part of your submissions on the contract, and obviously the tribunal and council are grappling with the true meaning of Clause 12. And this question slightly echoes a question from my co-arbitrator, Mr. Fei Ning. Are the words, seller shall not be responsible for, a problem for you, in that they might suggest that if the clause is triggered, it gives you a defense to a claim, a shield if you like, but doesn't found a claim, not a sword?
I understand that that remedy would merely be a shield, but the sword has been provided in accordance with the intent of parties. The first part of the paragraph indeed is a force majeure clause with a force majeure remedy. However, it was parties' clear intent that adaptation can be provided, and this adaptation should be provided in the present circumstances.
Thank you. Thank you very much indeed. Now, Mr. Shrikant, we will hear from you on behalf of respondent.
Am I audible? Good morning, members of the tribunal. As previously introduced, my name is Sudarshan Shrikant, and I will deal with the merits of this case on behalf of my client, Black Beauty Equestrian, who is the respondent in this proceeding.
Yes.
I have two broad submissions in this regard. That first, claimant is not entitled to any additional payment under Clause 12 of the agreement between the parties, and second, neither is it entitled to the same under Article 79 of the CISG. First, turning to the requirement under the contractual provision between the parties themselves, and I think this would be easier for everybody else in the room. Moving first then to the contractual provision. As pointed out by counsel for claimant, there are three requirements that must be met by Clause 12 and by claimant in order for them to be entitled to a claim of hardship. And we agree that these are in fact the three requirements. However, we disagree in the manner in which they are met or not. And let's turn to the first requirement, namely that of comparability. Claimant turns you to page 12 and tells you that since the fact that initially the parties contemplated to some extent of customs regulations and import restrictions being covered within the ambit of a hardship clause, that this must be the final intent of the parties. However, what counsel for claimant does not tell you is that these were not even close to the final negotiations of the hardship clause. Subsequently, our negotiator, Mr. Krohn, clarified that respondent only preferred a narrow hardship reference within the contract rather than a broad one, and Mr. Ferguson also agreed to the same. And therefore, to interpret this hardship clause to include any custom regulation or any import restriction would go to severely undermine the intent of respondent, which claimant expressly acceded to have a narrow hardship reference within the contract. Further, this hardship clause, nevertheless, must be read along with Clause 8 of the contract, which provides for a DDP delivery by claimant. The term DDP stands for Delivery Duty Paid, which expressly imposes all obligations and risks upon the seller. We agree that the parties have derogated from a DDP in this case and do not have a traditional DDP. However, the standard for a derogation from a DDP, even under the CISG, was laid down in the ICC case 7903 decided in 2010, wherein it stated that any derogation from a DDP must be explicit, so that if the parties wish to not have tariffs applied to claimant in this case, they must have written DDP no tariffs. And this in fact supersedes the rule of Article 8.1, for Article 8.1 is a general rule, whereas DDP is a special provision. And as with the general principle of law, going with special provisions over the general, we believe that the DDP should apply as an express provision over any implied intent that claimant can point you to.
So on that, on this first point, and we're focusing on intently on the meaning of comparable unforeseen events, what events do you say are, so the phrase is additional health and safety requirements or comparable unforeseen events. What category of events do you say comes within those three words?
Members of the tribunal, it is our contention that there's a myriad of events which could fall closer to additional health and safety requirements than tariffs. And these would be sanitary and phytosanitary measures under the WTO regulations and environmental protection measures under the GATT regulations once again. The reason these are far closer to additional health and safety requirements than tariffs are due to their nature and the purpose for which they are imposed. Additional health and safety requirements, by their purpose and by their character, are imposed to protect the health-related concerns of citizens and livestock. On the contrast, tariffs are imposed to protect economic interests of parties and are in no way life-related or health risk-related concerns. And this is in fact very important to commercial parties, as they must know what they must do under these requirements. And claimants suggest that this is what we must look at. However, even in the interest of commercial parties, the judgment of comparability shows that these are in fact not comparable. For additional health and safety requirements are technical requirements, namely simply asking for more testing and more product-related, quality-related checks, which are extremely important for commercial parties. Whereas on the other hand, tariffs simply require parties to pay an amount to the exporting authority or the importing authority, depending on the nature of the tariff, and therefore are significantly different from the manner in which they impose themselves upon a commercial party.
Thank you.
Moving then to the second requirement under the contract, namely that of whether the tariffs were unforeseen. I have two responses to the arguments made by counsel for claimant. First, counsel for claimant suggests that this requirement of unforeseen must be read as unforeseen rather than unforeseeable.
You do accept, I think, that it's a question which must be answered as at the 6th of May 2017.
Certainly,
Yes.
Mr. President.
Yes.
For the standard of unforeseeability, as noted by Professor Honor, is whether parties at the time of contract conclusion foresaw or contemplated of such risks. And it is our contention that this certainly has been met. By claimant's own submission, they contend that tariffs were contemplated on page 12 of the record, and that is why this tribunal should include them within the ambit of clause 12. However, in the same breath, they tell you that tariffs were in no way contemplated by the parties, and they could not have foreseen this at all. We believe that this is a stark contradiction within claimant's case that this tribunal must account for if it is true that the parties contemplated of tariffs in the email on page 12 on 31st March of 2017, it is also true that they foresaw the possibility of tariffs being imposed within the ambit of the contract, and therefore the requirement of unforeseen has not then been met. Moving to the final requirement.
Do you draw a... You heard, I think, the exchange between the tribunal and the counsel for the claimant concerning a possible distinction, and without accepting there is one, but exploring a possible distinction between unforeseen and unforeseeability, or put another way, subjective versus objective. What do you say about that? What's your position on that?
We have two responses to that, Mr. President. First, that this term unforeseen must in fact be read as unforeseeable. For even going by claimant's own contention that the email on page 12 is crucial in understanding the purpose of the hardship clause, Ms. Napravnik suggested the hardship clause only for unforeseeable risks in page 12 and not for unforeseen risks. And this can be seen at the 4th paragraph in the 3rd and the 4th line of that email. However, even if we were to look at the subjective standard, which is admittedly a lower standard, namely that of unforeseen, it is our contention that if the parties in fact contemplated of tariffs on the email of page 12, they did in fact foresee the risks of tariffs being imposed and the possibility of tariffs being imposed, and therefore they were not in fact unforeseen according to the intent of the parties. Moving to the final requirement, namely that of whether the contract has been made more onerous. Once again, to a certain extent, we agree with claimant on this matter, namely that the parties have in fact derogated from the standard of excessively onerous, which is the general standard of hardship under international law, and have admittedly set a lower threshold, namely that of more onerous. And I will not bore this tribunal with multiple citations of different percentages of hardship that different tribunals have set. However, we shall go under the principle of party autonomy under Article 8.1 of the CISG. As Mr. Arbitrator had correctly pointed out, Ms. Napravnik had stated that the standard for the commercial basis of the deal being destroyed was 40%. The response of counsel for claimant for this is that only the term up to must be considered here, and 40% is thus a ceiling for hardship and not a ballpark figure. However, it is our submission that such an interpretation of this email would lead to absurdities, for the reason that if 40% was a ceiling, then a 30% hardship could be considered to be hardship, but a 400% tariff could not be considered to be hardship, for the reason then that we are interpreting it as a ceiling rather than a ballpark figure that the parties were going for. Thus, this term up to 40% must be interpreted as a broad standard that must be met by these parties, in that the tariff imposed or any impediment that arises must be around this figure. In this case, claimant contends that it faces a hardship of 25 to 30%. However, we contend that their calculus for this is false. As Professor Brunner notes, in assessing the extent of hardship incurred by a party, the entire contract must be considered rather than singular installments. Upon considering the entire contract, simple mathematics dictates that in this case the tariff only amounted to a hardship of 15%, for the reason that the contract was valued at $10 million, whereas the tariffs were only imposed for an amount of $1.5 million, rendering it a 15% hardship, nowhere close to the standard of 40% set by the parties themselves. Therefore, the standard of more onerous has not been met under this contract. Given that none of the three requirements have been met, claimant is not entitled to any form of hardship claim. However, even assuming claimant's best case, that these three requirements are met, we submit that the remedy of adaptation is not within the ambit of the contract or Clause 12. Claimant heavily relies on a conversation between Ms. Napravnik and Mr. Antley on 12th April of 2017 at the annual Danubia Colt auction to suggest that the parties agreed on adaptation. However, this is in fact not the case. If the tribunal would turn with me to page 17 of the record, wherein this conversation is located in the witness statement of claimant's own negotiator, Ms. Julie Napravnik. If I could turn you to the 4th paragraph, it states that while claimant had initially asked for a mechanism to adapt the contract, Mr. Antley said two things. First, that he agrees that in his view, it would probably be the task of the arbitrators to adapt the contract, and in the same paragraph, 3 lines down, states that he would merely come back with a proposal the next morning. Therefore, all Mr. Antley was saying was that in his view, it would probably be the task of the arbitrators to adapt the contract. However, he must clarify with the head of the legal department, who at the time was Mr. Julian Crone, and come back with a proposal the next morning, thus in no way binding himself nor respondent to any commitment of adaptation.
Do you accept that account is a true account of what Mr. Antley said, or do you simply say we have no evidence from Mr. Antley and therefore the matter is open?
Mr. President, we do not need to look to Mr. Napravnik's account of the incident to look for evidence from Mr. Antley. In fact, contrary to claimant's suggestion, evidence of Mr. Antley's interpretation of this conversation can be found well within the ambit of the record at page 35 of the record in Mr. Julian Crone's witness statement. In the middle of the page, it contains a note maintained by Mr. Antley after the conversation with Ms. Napravnik. In this, the note is called List of Issues for Further Negotiation. And the final note under that is the connection of the hardship clause with the arbitration clause, referring to the remedies of hardship itself and thereby adaptation. Therefore, even after this conversation with Mr. Napravnik, Mr. Antley simply considered the question of adaptation to be an issue for further negotiation and in no way settled between the parties. Therefore, the parties under Clause 12 did not agree finally on adaptation as the remedy, and therefore this cannot be granted in this case. Moving then to my second submission, namely under Article 79 of the CISG. I have two broad submissions in this regard. That first, the parties have elected to derogate from Article 79, and second, that Article 79 nevertheless does not provide for the remedy of adaptation. Moving to the first one. Claimant suggests that the standard for derogation is whether the parties have expressed a clear, cognizable intent to derogate. However, this is not in fact the standard of derogation from singular provisions of the CISG. This is the standard for derogation when parties wish to exclude the application of the CISG in its completeness. However, the standard for derogation from individual provisions such as Article 79 is whether the parties have themselves included a special contractual provision to deal with a subject matter already dealt with by the CISG. And this was laid down in the Korn case decided in Ukraine in the year 2012. And therefore, in this case, going by that standard, there is a clear derogation for the fact that Clause 12 of the contract deals specifically with force majeure and hardship. However, taking claimant at its best case and taking its own standard into account, we contend that there is still a derogation. And before I move on to do so, may I please be given an extension of 1 minute to complete my submissions on this matter?
Of course, and as with claimant, a little longer than that if you need it.
Thank you, Mr. President. Claimant suggests that the parties have not displayed any intent to derogate from the CISG. But this again can be seen from page 35 of the record. Page 35, in the last 2 lines of Mr. Julian Crone's witness statement, states that Mr. John Ferguson and myself agreed to the inclusion of a narrow hardship reference into the force majeure clause and regulated some other risks directly in the contract. This shows that the parties relied on the principle of party autonomy to deal with the issue of risk allocation rather than any external legislation such as the CISG or the ICC hardship clause. Therefore, even going by claimant's own standard, there has in fact been a derogation from Article 79. Moving to the second question of whether Article 79 provides for the remedy of price adaptation. Claimant agrees with us that in the black letter of the law, Article 79 does not provide for the remedy of price adaptation. And it suggests, however, that we must look to the general principles of the CISG, and in particular, the principle of good faith, to show that a remedy of adaptation exists. And I have two responses to this. First, that in order to look to the general principles of the CISG, claimant must first show you that a gap exists within the ambit of Article 79. A gap can only exist, as noted by Professor Schwenzer, if something fell outside the contemplation of the drafters of the CISG. However, the drafters in this case expressly considered adaptation as a remedy under Clause 79, under Article 79, apologies, but expressly rejected the same as well, for it was a purely civil law remedy, and this is reflected in the travaux. Therefore, the drafters considered adaptation and expressly chose not to include it, and including it within the ambit of the CISG would expressly go against this intent of the drafters. However, once again, taking claimant at its best case and considering the principle of good faith, we suggest that the principle of good faith only furthers the principle of pacta sunt servanda, which requires the contract to be performed as it was rather than changing it in the future. And therefore, we submit that neither under Clause 12 of the agreement between the parties or under Article 79, claimant does not have a claim for additional payment. Thank you.
Thank you. Thank you very much, Mr. Srikanth. We'll now turn to the replies and the rebuttals.
We have one point to make, which is that opposing counsel has fundamentally wrongly interpreted Clause 12 and failed to look at this in accordance with the commercial logic that is most relevant for these commercial parties. This logic is that the purpose and effect of the clause was to exempt our client from responsibility for sudden government increases. Opposing counsel has pointed to some technical details as to what the tariffs and health and safety requirements would be aimed at. This is not what parties are concerned with. What parties are concerned with is with what the purpose of the clause was.
In the ordinary course, leaving aside the evidence that you wish to rely on concerning the party's intention, would you accept what Mr. Srikanth said, that essentially additional health and safety requirements or comparable unforeseen events envisages sanitary and environmental and health-related matters? Would you accept in the ordinary course that would be a fair interpretation?
We agree that actually phytosanitary measures and such things are exactly what health and safety requirements are, not necessarily comparable events. The comparable events are matters that are not exactly health and safety requirements, but related matters, such as tariffs. And opposing counsel has referred to a narrowing from the ICC hardship clause. We do not fail to acknowledge this, but it was merely narrowed in certain regards from any event to the events associated with changes in customs regulations or import restrictions.
Thank you. Thank you.
Members of
Sorry, and there was one other question I had for you. What did you say to Mr. Srikanth's point about some assistance can be gleaned from Clause 8?
Opposing counsel has referred to that there would be a more specific clause that would supervene the other clause. What is actually the mechanic is that there is a DDP clause which has been derogated from through Clause 12. Clause 12 is a carve-out from DDP, and this supersedes the Clause 8.
I see. Thank you. Mr. Srikanth, thank you.
Members of the tribunal, given that I have already addressed the issue of how important the nature of impediments are to commercially reasonable parties, I respectfully waive my rebuttal in the interest of the precious time of this tribunal. Thank you.
Thank you very much. I'll just ask my fellow arbitrators whether they have any other questions. Thank you. In which case, can I ask both counsel for claimant and counsel for respondent whether there is anything else you feel you need to say before we conclude these proceedings? Claimant?
No, Mr. Presiding Arbitrator.
No, Mr. President.
And secondly, do either of you have any objections as to the way in which the tribunal have conducted these proceedings?
No.
No.
In which case, on behalf of the tribunal, let me thank all four of you for your extremely helpful submissions and for dealing with our questions and for nonetheless keeping to time. And we will now retire to consider our decision. Thank you.